Good evening, everyone. I am Kalpna Bharti, Assistant Professor, IIMT College of Law, and today we will discuss the most important topic about concept of justice. So, first of all, we have to understand what is justice. So, this is the introduction of justice. Justice refers to a concept of fairness, equality, moral behavior, lawfulness, and order. It seeks to answer some questions like what are people ought and what makes a punishment just. Everyone from philosophers to policymaker to humanitarian is interested in what justice means. So justice has to do with how individuals are treated. It gives way to values of equality, liberty, freedom, opportunity, etc. Justice is the opposite of arbitrariness. It requires that where two cases are relevantly alike, they should be treated in the same way. So, where there is an arbitrariness, there cannot be a justice. So, there are some types of justice which are included or inculcated in different legal systems around the world. So, first of all, we will discuss procedural versus substantive justice. So procedural justice lays more emphasis on the procedure rather than the outcome. It says that if the procedure is correct, then whatever be its outcome, it is just. Procedural justice is concerned with making and implementing decisions according to fair procedure that ensure fair treatment. Rules must be impartially followed and consistently applied in order to generate an unbiased decision. So, when rules are applicable in fair manner, we can say there is justice. Those carrying out the procedure should be neutral, and those directly affected by the decision should have some voice and representation in the decision making process. If the people believe procedure to be fair, they will be more likely to accept outcomes, even ones that they do not like. Implementing fair procedure is central to many dispute resolution procedures, including negotiation, mediation, arbitration, and adjudication. So we can say when there is some fairness in rule making procedure or decision making procedure, people believe that they will get justice in that system. So in substantive justice, sub it is concerned with the way in which an individual evaluates important and meaningful things to produce an outcome. It is not just mere following the procedure. So, for example, we can say, let's assume that there exists a law which allows frisking of people selectively basis of a particular religion. Now, according to some procedural justice, the policeman is justified in frisking all Muslim or any particular religion, for example, as law permits. But according to the principles of substantive justice, selectively targeting someone on the basis of religion is unjustified. The law should require amendments. So, if a procedure is not justified on the basis of substantive laws or on the principles of justice, then substantially it is not a justice. Now, second type of justice is distributive justice. It assumes a distributing agent, that there is a distributing agent, like for example, a state and a number of persons who have claims like we common peoples. So on what, and it is based on a question of what being is distributed. So justice here require that resources available to the distributors be shared according to some relevant criteria. Means there cannot be arbitration in distribution of things or resources. Various social security schemes are example of distributive justice. So distributive justice or economic justice, we can say, is concerned with giving all members of society a fair share of benefits and resources available. However, while everyone might agree that wealth should be distributed fairly, there is much disagreement about that what counts as fair share. So here a question arises, what is the fair share? Someone can say this is not a fair share, or 50-50% or equally distributed is the fair share. So some possible criteria of distribution are equity, equality, and need. So fair share is based on these principles like equity, equality, and need. What is the need of people? If two persons have different needs, then the distribution can be based on the equity. So equity means that one's reward should be equal to one's contribution to the society, while equality means that everyone gets the same amount regardless of the inputs. Distribution on the basis of need means that people who need more will get more, while people who need less will get less. So this is all about distributive justice. We can further say that fair allocation of resources or distributive justice is crucial to the stability of justice society, and the well-being of its members. Different people will define fair differently. Some will say that fairness is equity and other equalities. Still others need. And the third type of justice is retributive justice. Retributive justice implies punishing an action which was illegal with an aim to deter it. Reformative justice implied this reformative justice is another type of justice which is opposite to retributive justice. So in reformative justice, it is implies in evolving a plan of action to reform the individual. So he does not involve himself in acts of crime. So there is some difference between retributive justice and reformative justice. Retributive justice focus mainly on the punishing a crime doer, and reformative justice focus on reforming the crime doer. Retributive justice appeal to the notion of just deserves, the idea that people deserve to be treated in the same way they treat others. It is retroactive approach that justifies punishment as a response to past injustice and wrongdoing. The central idea is that the offender has gained unfair advantage through his or her behavior, and that punishment will set his imbalance straight. The fourth type of justice is restorative justice. Restorative justice was developed in 1970, though many of its tenets come from indigenous justice practices. Restorative justice focus on helping victim of crime. So this type of justice, which we call restorative justice, it mainly focus on the victims, not the crime doer, but it also want to help offender understand the harm they have caused. So in this type of justice, we focus both and the harm which the offender has caused and compensating the victims. The goal is repair and not punishment. So in restorative justice, we repair the damage. We don't punish for causing the damage. Engagement, accountability, corporations, and community are all essential principles of restorative justice. So restorative justice practice has been used in many criminal justice cases, but they have also adopted during conflicts involving family, school, and workplace. Unlike retributive justice, restorative justice does not focus on what criminal deserve, but rather on what victim need to heal and what communities can do to prevent re-offending. So the main focus of restorative justice is the victim and not the offenders. So we have to compensate the victim the damage he suffered, uh, and the repair as much as we can do. While a reproductive justice approach conceives a transgression as crime against the state or nations, Restorative justice focus on violations as crime against individual. So there is some minor difference, or we can say the main difference between the retributive and restorative justice is that in retributive justice, we take crime as a offense against the state, but in restorative justice, we take crime as a offense against the individual. It is concerned with healing victim wounds, restoring offenders to law-abiding lives, and repairing harm done to interpersonal relation and the community. Restorative justice. In further, we can say, in this type of justice, victims take an active role in directing the actions that take place, as well as defining responsibility and obligation of offenders. Offenders are encouraged to understand the harm they have caused to the victims and take responsibility of it. Restorative justice aims to strengthen the community and prevent similar harm from happening in the future. So in this type of justice, we does we do not focus on punishing the offenders, but we focus to make the offender realize what harm he has caused to the person, to the society at large, and what we can do to heal that wounds which victims have suffered. At the national level, such processes are often carried out through victim offender mediation program. So in this type of justice, the uh, dispute resolution is revolve around the victim offender mediation program. Mediation centers are providing such services. While at the international level, restorative justice is often a matter of instituting truth and reconciliation commission. So in on international level, there are some commission which we say we call reconciliations commission. In national level, we have mediation programs, mediation centers for dispute resolutions. Fifth type of justice is reformative justice. At the heart of reformative theory of punishment lies the objective of reforming the character and behavior of the offenders. So we can say it is an extension of restorative justice, or it's a part of restorative justice, where we focus, in restorative justice, we focus on the healing of wounds of victim, but in reformative justice, we focus on reforming the offenders. Rather than merely punishing individuals for their crime, the emphasis is on understanding and addressing the underlying factor that contributed to their action. By providing support, resources, and opportunity for rehabilitation, the goal is to reintegrate offender as law-abiding members of the society. So, while the reformative theory of punishment has been influenced by various scholars and thinkers throughout history, Mahatma Gandhi is often cited as one of the most prominent advocates of this theory. Gandhi's philosophy of non-violence and compassion played a significant role in shaping the principle of reformative approach to the criminal justice. So we have discussed all the types of justice system around the world. Now we will discuss its applicability or its adoption in Indian legal system. So first of all, the distributive justice and Indian legal system. Article 38 and 39 of Indian Constitution defines distributive justice. Distributive justice means fair distribution of resources, as we have already discussed. So Indian Constitution defines three types of justice: social justice, economic justice, and political justice. Social justice means that equal social opportunities are available to every person for personal development of every person without any discrimination based on race, sex, and caste. Economic justice means providing economic opportunity, economic equality, and removing economic disabilities. it is always implemented under the umbrella of social justice. So economic justice is, is a part of social justice also. The third one is political justice, which means a system free from political arbitrariness. There should be political fairness in the working of the government. Political status of any person should not give any should not give him any advantage. He or should be treated like every other citizens. So there should not be any biasness or any special privilege to a person or class when we talk about economic justice or social justice or any political justice. Everyone should be treated equally. In our constitution also, under Article 40, which talks about right to equality, also it provides that everyone is equal before the law. So law should treat everyone equally, and there should not be any biasness or discriminations. So a restorative system in India. Now we will discuss the restorative type of justice in Indian legal system. So restorative system is not actively followed in Indian legal system, but there are some instances or some provisions in Indian laws where we find the scope of restorative justice in our legal system. So there are two areas where scope of restorative justice can positively have a bearing on or are as follows. First, the juvenile justice system or juvenile justice laws. The importance in juvenile justice system, the importance of rehabilitation and social integration clearly stand out if we appreciate the objective of Juvenile Justice Act, which is to foster restorative justice. Second one is victim of domestic abuse. So in the Domestic Violence Act or domestic abuse, any type of domestic abuse, we often follow the restorative type of justice. In situations where perpetrator is known to the victim, there is greater need to engage in dialogue to help both the parties to understand each other's stance and resolve the conflict brought about by the offense. It should also acknowledge that considering the gravity and frequency of a domestic violence case, a victim may decide to take part in restorative justice as well as be willing to prosecute the offenders simultaneously. So in this type of cases like a domestic violence act where we cannot punish a person, or we have to preserve some relations between the offenders and the victim, we follow this restorative type of justice often. So there cannot be, we can preserve the relations and the rights and the interest of victim as well as some interest of offenders. The third one is reformative justice in Indian legal system. In India, the reformative theory has shaped several key legislative frameworks and statutes. The Juvenile Justice Act, for example, prioritizes the rehabilitation of juvenile justice through measures such as education, counseling, community integration. So in Indian legal system, we follow a reformative type of justice in number of provisions. For example, Juvenile Justice Act. Similarly, our CRPC, the Code of Criminal Procedure, also provide alternative to incarcerations, such as probations, paroles, indeterminate sentences, focusing on the potential for reform rather than punishment and all. Constitutional provisions also provide some reformative type of justice. For example, in Article 72 and 161, which provide powers to the president and governors to pardon individuals, reflecting a commitment to fairness and justice within context of reformative principles. The retributive theory has significantly influenced the Indian legal system, particularly in shaping the principle of criminal law and sentencing. It emphasizes the idea that punishment should be proportionate to offense committed, serving a deterrent to the future wrongdoing while also just satisfying the societal need of the justice for the justice. So if we follow every kind of justice in Indian legal system, but our justice system is mainly focused on retributive theory of punishment or justice, where the punishment is proportionate to the crime committed by the individual. So we further in reformative theory of justice, we can say that it serves several key purposes, like rehabilitation may involve in providing education, vocational training, counseling, and drug, as we have already discussed. It aims to reform offenders and equip them with the skill and resources necessary to integrate into society as law-abiding citizens. So the principle of individual visualization, non-punitiveness, human dignity, and rights, voluntary participation, and community participation guides the approach toward the rehabilitation of offenders. Through various provisions in IPC, juvenile justice laws, restorative justice practice, and case laws, the reformative theory of punishment is recognized and upheld in India as a mean to promote the reforms and reintegration of offender in society. So we have already discussed various examples where reformative type of justice is implemented or followed actively in Indian legal system. Now, the conclusion part is in India, where the criminal procedure laws do not explicitly mention this justice system, but different provisions offer features of these models of justice. This system, especially restorative justice in India, aims to address some weakness of Western legal system by involving victims, offenders, and community in settling dispute. Though this type of justice, like restorative justice, is not actively followed in India, but it has some essence in Indian legal systems. In India, criminal justice system is based on retributive justice. So main focus of Indian legal system is based on retributive justice, which focus on punishing the lawbreaker and compensating the victims. The punishment's severity is generally proportional to the seriousness of the crime. The criminal justice system in India aims to prevent crimes in society, apprehend and punish violators, and rehabilitate the criminals. Thank you.